There's a piece of paper sitting behind the counter at your bank right now. It's free. It takes 15 minutes. And the moment you skip it, you've quietly handed control of your life savings to a courtroom you'll never see, on a date you can't predict. Here's how that actually plays out for a real family. A woman sells the house she and her husband lived in for decades. She walks the proceeds into her local bank, a few $100,000, the kind of money that's supposed to take care of her kids. She does everything she's been told to do. She hires an attorney, she signs a will. She splits everything evenly between her son and daughter. She locks the document in a safe at home and tells both kids it's handled. It isn't. Not even close. She passes away suddenly. Her son drives to the bank with the death certificate and the notarized will in his hand. He sits down with the branch manager. He slides both documents across the desk, and the branch manager slides them back. Because here's what nobody warns you about. A will means nothing at a bank counter. Nothing at all. A will is a letter addressed to a judge, not a banker. It only carries legal weight once a probate court certifies it, and that can take months. Until then, the bank only cares about one thing: what's actually written on the account file. And on this account, only one name was ever written down: hers. The account is frozen. Not for a day, not for a week, often for the better part of a year. Meanwhile, the funeral home still wants paying. The flights to get there still cost money. And the kids, grieving, exhausted, and now also broke, end up putting it all on a credit card, watching interest pile up while a judge they've never met decides if and when they're allowed to touch money that was always meant to be theirs. This is what happens with zero protection in place, and it's avoidable with one form. So let's count down the 5 mistakes that put families in that bank lobby, and the simple fix for each one, starting with the most common. Mistake 5. Assuming the will handles everything. This is the myth that destroys more families than any other, so let's kill it right now. A will doesn't bypass probate. A will guarantees probate. It's an instruction manual that nobody's allowed to follow until a judge stamps it as valid first. The tool that actually skips the courtroom is something almost nobody asks for: the Payable-on-Death designation, often shortened to POD, sometimes called Transfer on Death, or TOD. This isn't advice for a judge to consider later. It's a binding contract between you and the bank, and it activates the second the bank sees a death certificate. All you have to do is properly notify your bank of who you want to inherit the money, and the bank and your beneficiary handle the rest, bypassing probate court entirely. NOLO. No attorney, no notary, no fee. There's generally no cost at all for an account holder to add this designation. Experian. Now replay that same family's story with one single change. Same sudden death. Same son walking into the same bank with the same death certificate. Except this time, the screen shows a name listed as beneficiary. All he has to do is bring the death certificate and proof of his own identity, and once the bank verifies it, he can access the funds as if they always belong to him. No judge, no filing fee, no newspaper notice most states require to alert unknown creditors, no year-long wait. Ricaforde Law Action Step. Pull out your most recent bank statement tonight. Look at the account holder name field. If you see the letters POD, TOD, or sometimes ITF next to your name, that account is protected. If all you see is your own name and nothing else, that account belongs to a probate court the day you die, regardless of what your will says. Mistake 4. Naming a beneficiary once and never looking at it again. People treat this form like a box to check off a to-do list. Sign it once, forget it forever. But life doesn't hold still. The person you named years ago might pass away before you do. They might divorce you. They might drift completely out of your life. If your named beneficiary dies before you, and the form is never updated, the account falls right back into probate. Full delay, full fees, the exact outcome you thought you'd already avoided. And depending on which state you live in, if you never remove an ex-spouse after a divorce, they could legally end up inheriting funds you never intended for them to receive. Ricaforte Law. Ricaforte Law. Action step. Name a primary beneficiary and a backup beneficiary, in case your first choice isn't living when the time comes. Then, put one recurring reminder on your calendar, once every few years, and immediately after any marriage, divorce, or death in the family, to walk back into your bank and confirm the names on file are still the names you actually want there. Mistake 3. Thinking one form covers your entire estate. This is where people overcorrect. They fill out the POD form, feel like they've checked the box on estate planning entirely, and stop thinking about it. But only the specific accounts carrying a POD designation actually skip probate, real estate, other personal property, and many investment accounts can still get pulled straight into the court process regardless of what's written on your bank account. Think of this form as one essential tool in a larger toolbox, not the entire toolbox. Nelson Law Firm, Bluffton. There's a related trap almost nobody mentions: the safe deposit box. People hand a spare key to their oldest child and assume that key means access. It doesn't. The moment a bank learns an account holder has died, that box gets sealed, key in hand or not, until the right paperwork shows up. And if the original will happens to be sitting inside that very box, you can end up in a genuinely circular nightmare. You need the will to start the legal process, but you need the legal process to retrieve the will. Action step. If you have a safe deposit box, add a trusted family member as a joint renter on the box itself while you're still alive. That single signature gives them standing legal access the moment they need it. No court order required. Mistake 2. Adding a child's name directly onto the account to help with bills. This one feels protective. It's actually one of the most dangerous moves on this entire list, because the danger doesn't show up until years later, usually without warning. The instant you add your child as a joint owner, the law treats that money as partly theirs, today, not after you die. If that child gets sued and loses a judgment beyond what their insurance covers, your account can be pursued to help satisfy it. If they go through a messy divorce, their spouse's attorney can demand a share of your savings in the settlement. If they fall behind on taxes, the money can be levied. If they file for bankruptcy, your balance can get pulled into their bankruptcy estate, simply because their name sits next to yours on the same piece of paper. A pod beneficiary carries none of that risk. They become the rightful owner of the funds only after you've passed away. Until that moment, they have no rights to and no control over the account at all. Your money stays entirely yours, fully shielded from their financial problems, for as long as you're alive. Associated bank action step. If you've already added a child as a joint owner purely for convenience, talk to your bank this week about removing them and replacing that setup with a POD designation instead. If you need someone to actually manage bills or deposits while you're alive, that's a different and safer tool. A durable power of attorney, which lets a trusted person act on your behalf without ever handing them ownership of your money. Their creditors, lawsuits, and divorces can't touch funds they were only ever authorized to manage, never to own. Mistake 1. Assuming this is settled and the same everywhere. Here's the mistake that catches even people who did everything else right. Assuming the rules never shift, or that they're identical no matter where you live. They aren't either. A payable-on-death account does come with real trade-offs worth understanding before you fill out the form, and the specific dollar thresholds that decide whether a smaller estate can skip formal probate entirely get updated by state legislatures fairly often. The amount that applied when your parents set up their accounts may not be the amount that applies today. ACTEC. There's also a wrinkle for married couples specifically. If you live in a community property state, your spouse may already hold certain legal rights to marital funds, regardless of whose name sits on the account. But that protection generally stops with the spouse. It doesn't automatically extend to children or grandchildren, so it's never a substitute for naming beneficiaries directly on the account itself. Action step. Don't assume the numbers you heard years ago from a friend, a forum, an old video still apply today. Rules change. And remember, if a POD designation names one beneficiary while the will says something different, the POD form wins. The will has no power to override what's written directly on the account. When in doubt, a quick conversation with a local estate attorney costs far less than a contested probate case down the line. Atlanta Wills and Trusts. So here's everything in one place, the entire fix laid out in order. Check your statement for POD, TOD, or ITF next to your name. If it's missing, walk into your bank and ask for the form directly. Every FDIC-insured bank in the country is required to have it. Bring each beneficiary's full legal name, date of birth, and social security number, because vague instructions like "my kids" won't be accepted. Name a backup beneficiary in case your first choice isn't living when the time comes. Add a trusted person as a joint renter on any safe deposit box you hold. Remove anyone you added to an account purely for bill-paying convenience, and replace that setup with a power of attorney instead. And revisit every one of these decisions every few years, especially after a major life change. That's the entire fix. No attorney required for most of it. No court. No fee. Just one form, sitting behind a counter at your own bank, waiting for someone to actually ask for it. Somewhere right now, a family is sitting in a bank lobby, staring at a screen that shows exactly how much money their parent left behind, and being told they can't touch a cent of it for months. The number's right there. Everyone in the room can see it, and the only thing standing between that family and their inheritance is one sheet of paper that nobody ever signed. Don't let that be your family. The form is free. It's already at your bank, and it takes less time to fill out than it took you to watch this video. If this changed how you're thinking about your own accounts, share it with the one person in your life who still hasn't filled this out. Chances are, that person exists, and they have no idea what it means for the people they love. This video is for general educational purposes only, and isn't a substitute for personalized legal or financial advice. Probate rules, beneficiary laws, and state thresholds vary by state and change over time, so it's worth confirming current details with a licensed estate attorney where you live.